Hello, I'm Jessica Lee, co-director of the Center for Work-Life Law at the University of California College of the Law, San Francisco, and director of the Pregnant Scholar Initiative, the nationwide legal resource center on the rights of pregnant and parenting students. Thank you for joining me today to learn a little bit more about the incredible changes that have taken place in Title IX in 2024 and now in early 2025. This session is a part of our recurring Title IX Tuesdays technical assistance sessions and webinars. We hope you'll join us for a future discussion. All the information you need is on our website, pregnantscholar.org. So here's what we're going to be talking about today. First, I'll give a very quick overview of how we got to the point that we're at right now. We'll discuss where we are now and what legal obligations apply to educational institutions as a result of the recent changes related to the Title IX regulations. And I think perhaps most importantly, we'll talk about what we do now. I will give a summary of the core obligations to pregnant and postpartum students as a result of the recent changes. And I will give an overview of some of the hot topics that keep coming up around supporting pregnant and postpartum students. These are taken straight from our technical assistance sessions and helpline. We won't cover questions in this presentation as it appears online, but if you join us for future Title IX Tuesdays, you will have a chance to ask any questions you want about how to best implement protections for pregnant and postpartum students on your campus. All right, let's dig in. How did we get here? As many of you know, the operative section of Title IX, the legislation, is 37 words. Here these words are on the screen. This is a massive mandate that changed our society, changed education for the better. But it doesn't provide a roadmap. It doesn't provide a lot of information about how exactly educational institutions are to ensure that no one is excluded from educational programs on the basis of sex. In order to get that more detailed guidance, federal agencies have put forward Title IX rules since the 1970s. Now, since the 70s, the rules on pregnant and parenting students have not changed until we get to 2024. The Biden administration put in place new Title IX regulations that dramatically changed the landscape for the better when it comes to supporting pregnant and parenting students. Unfortunately, those regulations were the source of a lot of controversy. We saw 9 federal lawsuits resulting in injunctions in 26 states and hundreds of educational institutions across the country in 2024. Most of these lawsuits challenge the definition of gender in the Title IX rules. They have some pretty significant implications for gender stereotyping broadly. We're not going to be able to get into that today, but I hope you'll join us for future sessions where we'll have a chance to unpack some of that. We also saw 2 lawsuits challenging the long-standing Title IX abortion protections. So coming out of 2024 and moving into 25, we saw a pretty significant chunk of the country unable to implement or no longer being able to enforce those Title IX regulations. And it was very confusing. I'm sure a lot of you have been keeping up to date with these legal changes, and it has been a lot. But in one of those cases, there was recently a decision which changed everything for the entire country. In the Eastern District of Kentucky, Judge Reeves vacated the 2024 Title IX rule nationwide in a decision that was focused on gender. As a result of this one judge's decision, the U.S. Department of Education is now unable to enforce the 2024 Title IX rule nationwide. The Department of Education, which, as you know, has changed dramatically since the inauguration, has stated that it will be applying the regulations as amended by the 2020 rule. In other words, they will not be enforcing the 2024 Title IX rule um, anywhere in the country. That said, courts will continue to enforce Title IX. Um, Students and employees can bring lawsuits under the law. It still applies. And there is a heck of a lot of legal precedent out there that is influencing how exactly courts are going to rule on it. What does that mean for educational institutions? Well, first of all, I want to thank all of you who worked so tirelessly to implement those 2024 regs. I know that you all spent so much time and energy into getting that implementation right. And my heart really goes out to you because I know this is a lot of change within a very short period of time. But there is a little bit of good news here. In terms of what you should do, well, institutions should apply the pre-existing Title IX rule as their baseline for compliance. And I underline that very intentionally um, because you don't need to throw everything out, right? The 2020 regulations are the floor for your compliance. So, as a result, policies enacted in 2024 that do not conflict with the 2020 Title IX rule can remain in force. We do have some really important areas of conflict here. You know, the definitions of discrimination and harassment are definitely at issue. The investigation and hearing protocols uh, can be pretty challenging. You know, for example, one regulation says to have live hearings. There's little or no leeway to implement a different approach there. However, there are a number of issues specifically relating to pregnant and parenting students where you don't need to make any changes based off of the policies and procedures you implemented under the 2024 regs. And on that note, I do think it's important to flag that while the entire opinion from the Eastern District of Kentucky was concerning, it is very important to note that Judge Reeves did not find constitutional issues with the 2024 protections for pregnant and parenting students. In fact, the judge explicitly noted in the opinion that there were no issues with those provisions, but said the whole rule needed to be cast aside anyway. Let's dig into how the rules should be interpreted by your educational institution now. I should flag, this is not legal advice. I hope that you will consult your general counsel or other attorneys that are more familiar with your specific circumstance. But these are the main takeaways from our analysis of the law, past Department of Education interpretations of the law, and also the court decisions that are out there on pregnant and parenting students. So, how do the rules conflict? Well, in the provisions on pregnant and parenting students, the 2024 regulations largely focused on process and on reducing barriers to accessing the long-standing protections from prior rules. So they weren't rewriting the whole thing here. They were just bringing the law to life with some more detail and more structured guidance to clear up some areas of confusion that have plagued us since the 70s. Implementing these changes is actually compliance best practice, and it reduces the potential liability because it ensures that your educational institution is successfully meeting those long existing requirements under Title IX regulations. I'm going to unpack what that means a bit. We'll start first with just a very quick summary of the core protections that the Title IX regulations provide to pregnant and postpartum students. First, the law prohibits discrimination on the basis of pregnancy-related conditions. Before 2024, the regulations explicitly listed a handful of conditions in a section titled Pregnancy and Related Conditions. There was some question amongst people as to whether other conditions were covered, but of course, the Department of Education has found that no, all pregnancy-related conditions should be protected under Title IX. So in the 2024 regs, the Department of Education spelled out some additional related conditions that are frequently occurring, and made clear that the list is not exhaustive. There's no conflict here. Next, schools are required to provide medically necessary leave. Before 2024, leave needed to be provided for as long as medically necessary, as determined by the student's physician. In the 2024 rules, leave had to be provided for as long as medically necessary, but the one change there was that it could be determined by any licensed healthcare provider. Again, the core principles are exactly the same. The devil's just in the details there, but no reason why educational institutions can't continue to have a broad certification requirement. I'll dig into what that means in just a moment. Finally, schools are still required to provide reasonable obligations to students with pregnancy-related impairments. Before 2024, there was that right to supportive measures to ensure that all students, including those who are pregnant or have pregnancy-related conditions, had an equal educational opportunity. But we often saw people using a comparative analysis between pregnancy-related impairments and temporary disabilities. And there was a heck of a lot of confusion over who exactly was responsible for doing what. In 2024, the Department of Education spelled out an affirmative right, but again, it was all rooted in that disability precedent. We'll unpack what that means, but the bottom line here is that the right to reasonable accommodations still exists. There's just a little bit more wiggle room in how you do it. Okay, turning back to non-discrimination. The 2024 rule codified Ed's view of pregnancy-related conditions, again, in line with previous interpretation. Here's some examples. We saw a lot of controversy about the abortion-related provisions in the 2024 rules. Any of you who read the comments to the proposed rules should be familiar with this. There were many thousands of comments about abortion, but I think it's really important to know that termination of pregnancy, which is the technical term that refers to abortion, miscarriage, and pregnancy loss, has been protected since Title IX first became law. Ever since we had those very first regulations, there has been a provision for protecting students on the basis of termination of pregnancy. There's nothing new here. Here's another example of a condition that is and was covered by Title IX, lactation. Lactation was not explicitly listed in the regulations before 2024. That said, we know from legal precedent that lactation is widely considered a pregnancy-related condition and widely considered a sex-linked condition. Lactation's been defined by courts as a pregnancy-related condition pretty reliably since 2013. And as such, students who are lactating should have an equal educational opportunity under Title IX. We'll talk a little bit more about how to get this right. There's certainly a lot of specifics here about how you do this that are a bit in flux, but the core protection here, the fact that you can't discriminate against students who are lactating, can't discriminate against students who've had an abortion or miscarriage, still applies. The next core obligation here is leave. The Title IX 2024 rule and earlier rules have all interpreted the law as requiring leave for as long as medically necessary. And after that leave, the student must be reinstated to the status they held before taking that time off. I should note time off has, again, long been interpreted by the Department of Education to include various periods of time. I encourage you to dig out that pamphlet and dear colleague letter on supporting the needs of pregnant and parenting students, which specifically refers to absences. It doesn't have to be a lengthy period of leave. But here's the difference. The 2024 rule said that leave could be based on, or what is medically necessary leave, which must be provided under Title IX, could be based on the advice of any licensed medical provider. Before 2024, the regulations said that medical necessity was as determined by a physician. So you are no longer required to approve leave based on the advice of a non-physician. However, there is nothing within the regulations that prohibit you or your institution from accepting certifications from other licensed qualified healthcare providers. Now, this is it's more of a best practice question, right? And it certainly is best practice to allow students to submit notes about medically necessary leave for pregnancy and related conditions from whoever they are seeing for their care. For example, many midwives would like to submit notes. A lot of times students are seeing nurse practitioners for follow-up visits rather than the OBGYN. These licensed healthcare providers should be able to submit notes to you. It would make the student's life a heck of a lot easier because in many locations right now, it is very, very challenging for students to actually get appointments with OBGYNs. There is a struggle to get care. I will say I find the struggle to get care is most acute in early pregnancy. It's most acute in rural areas and underserved areas generally. This could be a real burden on students, and one small change to your practice could alleviate some of that burden without conflicting with previous Title IX regulations that are now in effect. The next core issue is accommodations, and this was the huge one. We were certainly celebrating the changes brought by the 2024 rules, but there are still some core obligations even without those 2024 rules. Students with pregnancy-related conditions are still entitled to reasonable academic adjustments. These are also known as reasonable accommodations or reasonable modifications. In order to be eligible for an accommodation, the student doesn't need to have a complication. We don't need some severe diagnosis here. They don't need to be on death's door. They just need to have an impairment in need of relief. Now, to meet your obligations to these students, you should provide them with an interactive process that should be familiar to you from the disability context, hopefully, or the 2024 rule. But all that means for newcomers is to sit down with the student, understand their impairment, and work with them to find accommodations that meet their health needs without causing a fundamental alteration to the essential nature of their course or program. And of course, in doing so, pregnant and postpartum students with impairments should not be treated worse than students with disabilities. The need to provide these accommodations has long been a part of Title IX. But of course, we got a lot more detail in 2024, including one really important piece, which was going over the process, right? The new Title IX regs spelled out that Title IX coordinators were responsible for facilitating this accommodation process. That educational institutions needed to inform students who reported their pregnancy to contact the Title IX coordinator for help and getting accommodations and leave. And the 2024 regulations did have a mandatory reporting requirement as well. Now, you no longer are required to implement those 2024 changes, but a lot of that is best practice. It's certainly supportive of pregnant and postpartum students to inform them of where they can go to get assistance. And I would argue that doing so is actually going to limit your liability under the 2020 regs or any interpretation of Title IX. If you're waiting until a student is in crisis, or until the discrimination has already occurred, that's just inviting liability and frankly, inviting more work for your administrators and staff. So the more that you can do to inform students of where they need to go to get the accommodations they need, the better off everyone is going to be. And there's nothing in the 2020 regs that prohibit you from doing that. In addition, another key takeaway that I hope you'll bring with you from all of this is that we should be cross-training folks in various departments that deal with accessibility and in Title IX. Now, under the 2024 Title IX regulations, accommodations could be handled by the Title IX coordinator or their designee. We no longer have that detail to operate from. Um, I expect many institutions are going to be providing their pregnant students with accommodations through their accessibility office. Perfect. But that accessibility office staff should be trained in the unique nature of pregnancy related impairments and accommodations, and should be trained in the ways that Title IX is unique. For example, the provision on medically necessary leave. Um, it is really important to have those clear lines of communication to open up that training. Um, I often suggest to institutions that if they are going to support their pregnant students through the accessibility office, that there be a point person at the accessibility office who has that training and who checks in with the Title IX coordinator regularly. And again, that the students still be informed of exactly where they need to go, particularly the fact that they could come to the Title IX coordinator if they do experience problems or need assistance. Again, the focus here is prevent, 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 right? We want to prevent problems before they occur. The new legal regime that we're under still gives you a ton of leeway to do that. But the important part is that you not just throw out all of these changes, but you take some time to actually work through how to continue implementing them and integrating them into your systems. So again, on this hot topic of notification, there is no requirement, but you absolutely should do it. Letting students know where to get help is, in my opinion, never a bad thing. Here's another hot topic, documentation. How exactly do you assess the student's impairment or their need for leave? Um, this was another point where we got a lot of very helpful guidance from the 2024 regulations. The 2024 rule implemented limitations on documentation requests. Pre-existing regulations had no limitations beyond the basic ban on discrimination. But this is another place where you have a lot of leeway to implement best practice to support your students. Given the time-sensitive nature of pregnancy-related impairments, the potential for bias, and students' difficulty accessing OBGYN care, maintaining limitations on documentation is absolutely a best practice. So you may want to review your disability policies to identify ways to bring parity and add documentation assumptions to your procedures. Here's an example of that. Under the 2024 rule, educational institutions could not ask for medical certifying documentation just for a student to have access to additional bathroom breaks or breaks to drink water or eat throughout the day. We know that pregnant people are going to need more bathroom breaks. We know that they're likely to need to eat and drink more often. And a self-attestation of that need was considered sufficient. You don't need to send a student to a doctor to have some medical documentation that she would need water breaks. The regulations now do not require that you make the presumption that those requests are reasonable. They don't require that you don't ask for documentation of that, but it's certainly in everyone's interest for you to keep on going with those assumptions and limiting your documentation requests. It's certainly going to help the student. They're not spending their time and money shuffling between medical appointments if they can even access them. And it's also helpful to staff because you would no longer have to waste staff time having an interactive process with the student just so that they can go to the bathroom or get a desk that actually accommodates their body. So this is going to save you time, and I also believe it's going to limit liability because you are sure that you're giving students what they need without nitpicking these very small, clearly necessary requests. If you want more guidance on the sorts of changes and documentation practices that would be most supportive for pregnant and postpartum students with impairments or who need leave, check out our guide to Title IX documentation standards. Now, obviously, this was written under the 2024 rules, but it's chock full of ideas of ways that you can be streamlining your process, limiting the documentation burden both on your staff and on your students. Here's another hot topic, lactation. Can't tell you how many calls I have gotten about lactation. Well, the Title IX rule implemented a requirement for lactation spaces and reasonable breaks, and that's in 2024. But pre-2024, there was no explicit requirement. Just legal nerds like me have read that standard into Title IX because we know, again, that lactation is a pregnancy-linked condition. Courts had not determined that in the 70s when the old Title IX rules were written, but we now have clear guidance in all sorts of settings that yes, lactation is a sex-linked condition, and as such, people are entitled to accommodations to meet their needs to ensure that lactating students have that equal educational opportunity. Now, we have a fact sheet on that interpretation at the Pregnant Scholar, but the basic premise is simple. Not providing students experiencing sex-linked conditions with facilities to meet their health needs means that those students aren't getting their equal educational access. And so that's really the test, is are we providing enough support that students are able to continue their education on the same footing as others without having to sacrifice their health? And as I say often to college administrators, you could think of this really simply. If you wouldn't operate a campus without women's bathrooms, why would you operate one without lactation spaces? Now, the Title IX rules in 2024 gave us a roadmap for how to best meet those students' needs. And I think those should still be the bottom line here. It's still best practice to support your lactating students by providing them with lactation spaces that are clean, not a bathroom, free from intrusion and view, and appropriate and functional as a lactation space. I also encourage you to remember when it comes to breaks that lactation breaks are widely considered medically necessary and could be viewed as medically necessary intermittent leave under Title IX's leave and absence provision. I often get asked by folks how many lactation spaces is enough. There's no bright line rule here. There's a few calculations that folks have used in the employment sector, but that, of course, is a somewhat different population. Again, the bottom line for all of this is to make sure that you have enough spaces available so that lactating students are able to access them when they need it and are not suffering. They're not getting an unequal educational opportunity as a result of not having the lactation space they need. So it's going to vary from campus to campus, but it really is ideal that you communicate who to contact for support here so that if students are not getting their needs met, you can find that out early and intervene before a violation has occurred. One more point to remember here on the lactation front is that employees, which were, of course, provided the right to lactation breaks under the Biden Title IX rule, they're still protected. They're just protected under other federal and local law. So employees do remain protected under the PUMP Act, the Fair Labor Standards Act, the Pregnant Workers Fairness Act, and in most states, also state or local law. And these laws require that employees have access to a private, non-bathroom lactation space and the as-needed break time to use it. In most states, that protection applies for at least 1 year and then continues for as long as it does not cause an undue hardship to continue providing the breaks and space. So you're already required to provide these spaces for all of your employees, including student employees, short-term employees, tenure, non-tenure, doesn't matter. But I hope you will provide it to students as well. For more information on your specific requirements to accommodate lactating employees, please see the Center for Work-Life Law's website at pregnantatwork.org for more information on your obligations to employees. Almost there. Here's another hot topic that's really important in this day and age. Under the 2024 rule, there could be only limited disclosures of students' personal information collected to comply with Title IX. Before 2024, there were extremely limited disclosure protections. So the Title IX rule last year made clear that students' health info would only be used to further access to education, not for investigation. We no longer have that safeguard. So I encourage educational institutions to review their data collection policies, retention, and data sharing procedures to make sure that you're implementing as many safeguards as state or local law will allow. This is incredibly important in this post-ops world where students' reproductive health decisions are under a lot of scrutiny. And it's important to all pregnant students because it can feel incredibly violating to have their pregnancy revealed without their consent. So pregnant people in many states are really nervous to ask for help because of the current climate. If your educational institution wants to enable people to fully be able to exercise their Title IX rights, you need to make it as safe as possible for them to do so. So I hope that you will meet with your general counsel, meet with your full team here, and look at what you can be doing, of course, within the constraints of the law, to make sure that you have the best privacy security standards that you possibly can. And very importantly, that staff are trained on how to keep student medical information related to pregnancy safe. I expect we're going to do another session specifically on this on the coming months. I know this is a tricky issue for folks legally, but I hope you will at least be starting these conversations. The 2024 Title IX rule gave you a bit of a shield to keep students' records safe and to not need to turn those over. You no longer have that shield, but institutional policies can help fill some of the gap. And it can help students understand their rights, their risks, and how the school is going to support them if you're actually sharing some of the safeguard steps that you're taking. Okay, finally, our last hot topic. I know a lot of you are probably saying throughout this presentation, what about other parents? The 2024 Title IX rule defined parental status, and it reaffirmed that discrimination on the basis of sex and parental status is prohibited by Title IX. Pre-2024, there was no definition of what a student parent was, what parental status was. But again, there was that prohibition saying parents cannot be treated differently on the basis of sex. So not much has changed here. We just got a more clarified definition of what we mean by parental status. Nothing has changed in regard to whether or not you can discriminate against parents on the basis of sex. You can't, that's illegal. But I do encourage folks to use that 2024 definition. There is nothing in the old regulations that prohibit you from using that definition. And the definition of parental status was crafted in line with other federal laws. So hopefully that's going to help you, again, keep things streamlined and consistent. That said, we knew that even that very supportive 2024 rule was not doing enough to protect parenting students beyond that postpartum period. So if you are not a birthing parent, the 2024 rule and the 2020 rules and all the way back to the 70s, they weren't providing that much for you, except for this general prohibition on sex discrimination. Of course, we know that student parents need a lot more support than that, and can really thrive when they get proactive support. So I always encourage educational institutions to implement institutional level policies that are going to be family responsive and make sure that these students do have a fair shot at getting their education. There's certainly a lot of barriers that we see at educational institutions, but you have a lot of leeway to implement changes as needed to make sure that those barriers are broken down. So I encourage you to address this at the institutional level as you go through and you're making changes to support pregnant and postpartum students. It's also a great time to sit back and think about how you can be supporting this student population. I do want to add a note here to remind folks that parenting students in higher education, the majority of them are students of color. So as we see diversity initiatives being whittled away or unfortunately in many jurisdictions shut down, I know a lot of you are looking for what you can do to make sure that you are not losing talented students. This is one way you can be supporting students of color that everyone from all political persuasions agree on. We want to give parenting students a chance so that they can fulfill their goals, and so that their families are better off for it. Okay, finally here, I'll get off my soapbox. I just want to flag Pregnant Scholars' response to all of this. We have our little to-do list. We are working as fast as we possibly can to reinstate pre-2024 rule materials to our website. It's going to take a bit of time. Just like you, we had just finished all of that work to adapt everything for the 2024 rules. Now we're going to wind some of that back. But we will continue to keep those 2024 implementation tools on a separate page to aid you all in looking toward best practice. And as we adapt all of our materials, we will keep flagging, what the core legal requirement is, and then how you all can go beyond that to make sure that you are reducing liability and supporting this student population. We have an explanation on why implementing most of these 2024 best practices fosters that compliance with pre-existing regulations. Please look for that on our website. And then just sort of as a general note, we are going to be supporting state and local enforcement of best practices and advocating for the reinstatement of the 2024 rules provisions on pregnant and postpartum students. So if you are looking to take action, we hope you'll join us. All of our materials related to these recent changes are at the website that you see there at your screen. We will continue to keep posting updates on the legal changes, providing materials and model policies to help you comply, and continuing to offer sessions like this to give an overview of what the law requires and how to best meet it. So please bookmark that page. You can also find a spot there to sign up for our newsletters and future trainings. Thank you again for all that you're doing to support pregnant, postpartum, and parenting students. We know that this is a challenging time, but please remember that we are here to support you. We have our technical assistance sessions and our helpline available to administrators and students alike. If you need support, please do ask for it, and we hope to see you at a future training. Thank you.